It often happens that an employee creates an invention or helps create an invention while working for someone else. The question can arise, who owns that invention? It's important for employers and employees to understand the law about when the employer has rights to inventions made by the employee. In the United States, an employer does not own that invention, even if it's created by an employee, unless the inventor transfers his or her rights to the employer. Specifically, the employee has to sell or license the invention to the employer, or the employer won't have rights to it. And this is the law for independent contractors who create an invention as well. If a patented invention has more than one inventor, then each of them owns the patent jointly and equally. That means they can each do what they want with the invention, unless they all have transferred ownership to the employer. And employees don't have to do that, meaning that there's no law that requires employees to give their employer rights to an invention they made. Now, of course, the employer might have thought of this beforehand and might require employees in a written agreement to assign those patent rights as a condition of employment. That would be an agreed employment term and it would be enforceable. When companies want to have this kind of an agreement to protect their investment in proprietary products, that contract is called an invention assignment agreement. It gives an employer specific rights to inventions created by the employee or contractor, and it usually requires an employee to do two things. First, transfer ownership of the invention to the employer, and also help the employer get a patent. Invention assignment agreements usually have a waiver provision to cover pre-employment inventions. In that waiver provision, the employee lists all inventions that he or she conceived before starting employment. That prevents an employee from claiming that an invention created on the job was actually conceived before the job began. These invention assignment agreements protect both the employer and the employee, so it's important to make sure they're accurate and complete. Some states restrict how far an invention assignment agreement can go. For example, California prohibits an invention assignment agreement from covering inventions that the employees created on their own time, even if they came up with it while an employee of someone else. To make sure you cover local peculiarities like this, you'll want to make sure you have a knowledgeable lawyer draft any invention assignment agreement. Now, if a patent exists, patent assignments are also likely to come into play. It's crucial to make sure they're clear. If you're an employer, you'll want to make sure there's an assignment for each patent and that there's no mistaking what the assignments cover. On the other hand, if you're the employee, you want to make sure you're not transferring intellectual property that you created on your own time. There's also a term called shop rights. That refers to an employer's right to use technology that was developed using support from the employer. It's not as broad as the rights the employer would have if there's an assignment. It only gives a company a non-exclusive right to use the invention without paying anything. It's not the same as ownership rights, but it's definitely useful. Shop rights cannot be transferred or assigned. They apply only to the employer. There's also a related term called collaborative rights. Companies sometimes collaborate on inventions, and when they do, each company involved shares partial ownership rights in what they invented together. In a case like that, each company has collaborative rights, which they can use themselves, or they can license the invention without approval from the others. In a situation where companies are collaborating to create an invention, it's smart to have an agreement that lays out everybody's rights to whatever gets invented.